So guys, Nnamdi Kanu's release is what is obtainable at the moment. As we all continue to seek for Nnamdi Kanu's release, Tinubu and his government keep frustrating Nnamdi Kanu in the court, bringing out fake reports from nowhere, and all the terrorism-related charges they keep bringing against Nnamdi Kanu. As we all know, of recent, Nnamdi Kanu declined to enter defense, saying that they don't have any charge against him. I keep telling you guys all the time that Nnamdi Kanu is a man of boldness and confidence. Anything he seems to speak out is all what is nothing but the truth. Nnamdi Kanu said, "Look, I am ready to go out all alone. I'm ready to defend myself in court. I don't need any lawyer. I want to defend myself. I want to prove to these people that I am innocent. Despite all the fake reports they keep bringing." They forged a fake report from the Nigerian Medical Association telling them that I'm fit to stand trial when I am not. My health is deteriorating. Nnamdi Kanu is not in good shape. He said, okay, if you guys say that I am fit to stand trial, so why are they lungs on my armpit? This is what Nnamdi Kanu came out to say. That is to tell you that he is not in good health, he's not in good condition. But they keep forging it and making it look as if Nnamdi Kanu is strong. They are covering it so that people will not know that Nnamdi Kanu's health is deteriorating in the court. Nnamdi Kanu must be released. Enough of all this. All this nonsense has to stop. Tinubu need to release Nnamdi Kanu now, because it is getting tense and tense in the court every day. Well, without wasting much of your time, there is a video I want you guys to watch. And when we are back, we will definitely continue so that we will know exactly what Nnamdi Kanu said in the court today.
So I was actually surprised that a high court have refused to obey or abide by the determination of a Supreme Court judgment.
And then take the only part that is against him and then refuse to apply the part that is in favor of him.
This cherry picking of what was contained in the Supreme Court judgment is what I'm against.
Yes, that's correct.
It should be implemented holistically.
Yes.
I'm not against facing any trial.
After
all, I'm innocent. They have not been against me. But there cannot be any trial when key sections of the Constitution and a key Supreme Court judgment has been violated by a court of law.
So you'll be patient for the case to go back and come back to the court?
This is my 4th year in solitary confinement in detention. The 5th year will not kill me.
Sorry, what if the case is also reassigned back to her? Will you still become
It's not going to happen.
No, it won't happen.
It won't happen. It doesn't happen.
It doesn't happen that way. It doesn't happen that way at all.
Thank you very much.
These are the things that the public must understand. Most of you journalists, the legal correspondents, you don't take time to actually study some of these rulings and judgments. Go and study. In fact, I'll give you...
Bring that envelope. Bring the envelope. Look at it here. Look at it here. Look at it.
I'll give it to her because I think she's a bit more...
Give her the Supreme Court judgment.
Can you hold this for me?
She can...
I want to let the whole world understand something. Very, very clear. In all this is judgment of the Supreme Court. It made it very clear that even that the impartiality of the judge is questionable. And it's here. Where is the? Please do bear with me. It says it here.
I like
what is it. Page? What is that again? Where it says all these things are online. Is it not page 18? All these things are online. So I suggest that the journalists in this country actually take out time to do some basic research. It's not difficult, just minor research. You will understand the virtuousness, the emptiness of all the charges against me. Okay. They kept switching the charges. Yes. They said I committed this crime in England, isn't it? Yes. I made a broadcast in England.
Yes.
And in 9 charges leveled against me, this place where I committed this crime was London, in the United Kingdom. Yes. When my lawyers came to see me, I had a discussion with them about how I'm going to defend myself. I told them that no court in Nigeria has jurisdiction to try me. Because since this offense was committed in England, so they said. It's only a UK court that can give a Nigerian court the authority to proceed, isn't it?
Yeah, based on that, they removed London.
Based on that, they now amended the charge again and removed London.
Location of the broadcast.
Location of the broadcast. Contrary to section 196?
174 of the Terrorism Prevention Act 2022.
In violation of their own laws. Violation of their own laws. And you want me to stand trial under such circumstances? Is that possible? Nnamdi Kanu to stand trial where these shenanigans are going on? It's not possible.
Because
Welcome back once again, guys. I believe we've watched the video that was just displayed to you on your screen. And you can now hear and see exactly what Nnamdi Kanu is trying to say. Nnamdi Kanu is saying, how is that possible? Why would they be putting up all these charges on me when I'm innocent? Bringing out terrorism-related charges on me. I'm a man of peace and injustice. I don't like all this, but they keep bringing it on me to make it look as if I have something bad I did also. Well, without wasting much of your time, like I said, we'll be getting into full details so that we'll know exactly what transpired in court today. Now, let's read. Nnamdi Kanu files fresh motion, asks court to strike out all charges. Says no charge exists against me under Nigerian law. Let's read in full details. The detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has filed a new motion before the Federal High Court in Abuja, asking the court to strike out all charges against him and order his immediate release. In the new court document obtained by Sahara reporters on Friday morning, the motion is titled Motion on Notice and Written Address in Support and dated 30th of October 2025. Kanu, who is representing himself in court, told the trial judge that there is no charge or count cognizable within the corpus juris of the Federal Republic of Nigeria against him, insisting that the charges are a nullity ab initio for want of any extant legal foundation. The document, filed pursuant to several constitutional and statutory provisions, including sections 1(3), 6(6), and (b), and 36(12) of the 1999 Constitution, the Evidence Act 2011, and the Terrorism Act 2022, forms part of Kanu's continued legal challenge against his ongoing prosecution by the Nigerian government. Kanu asked the court to make an order striking out its entirety the purported charge of as it fails to constitute any offence known to law, noting that the prosecution had relied on repealed and non-existent laws, namely the Customs and Excise Management Act, CEMA, Cap C45, LFN 2004, repealed by Section 281(1) of the Nigeria Customs Services Act 2023. And the Terrorism Prevention Act 2013, repealed by Section 97 of the TPPA 2022. He argued that the repealed statutes vitiate the charged legal foundation and offend the principle of legality enshrined in Section 36(12) of the Constitution. Kanu also urged the court to declare that there exists no lawful or constitutional basis for his continued trial or detention in the absence of cognizable charge under any extant law of Nigeria. Citing the Supreme Court's decision in FRN v. Kanu, the IPOB leader reminded the trial court that the Apex Court had directed lower courts to take judicial notice under Section 122 of the Evidence Act 2011 of non-extant statutes, stressing that failure to do so renders all proceedings void ab initio, as non-compliance with a superior court's pronouncement is a constitutional violation. Kanu further claimed that the counts against him, specifically count 1 to 6, were allegedly committed in Kenya, which according to him contravenes Section 76(1) d III of the TPPA 2022. That section, he said, mandates validation by a Kenyan court confirming the act's criminality in Kenya, a condition precedent unfulfilled pre-plea, thereby nullifying extraterritorial jurisdiction. He argued that this omission offends Article 7(2) of the African Charter on Human and People's Rights. Quoting Section 1(3) of the Constitution, Kanu maintained that any law or judicial pronouncement inconsistent with the Constitution is void ab initio, adding that the Nigerian Constitution prohibits trial on a charge not defined in an extant written law. He cited earlier decisions such as Aoko v. Fagbemi 1961, 1 all NLR 400 and FRN v. Ifegu 2003, 15 NWLR 113, where the courts nullified convictions resting on non-existent offences. So guys, these are the reports that Nnamdi Kanu gave in the court today. Nnamdi Kanu went to the court and he filed out fresh motion, telling the court, look, strike out all the charges. There are no charge exist against me under Nigerian law. This is exactly what I'm telling you guys, that Nnamdi Kanu is a man of boldness and confidence. You can see what he went to the court to say today. There are signs now that Nnamdi Kanu will be released. And yes, Nnamdi Kanu must be released. Well, I'd love to have your take on this. Tell me what you think in the comment section. Like this video. Share this video. Always leave a free Nnamdi Kanu in the comment section. And most importantly, hit the subscribe button and turn on this channel notification bell so that you won't be missing any trending updates about Nnamdi Kanu.